Welcome to Lessons from the Sensei, Law, Business, and Life.
Hello, everyone, and welcome back to Lessons from the Sensei, Law, Business, and Life with Denis Quintana, veteran Orlando defense attorney. I'm Sean O'Connor, and today Dennis and I are talking about your first court appearance in Florida. For most people, that first time in court is a shock. You don't know where to stand, what to say, or what the judge is actually looking at, and what people expect going in is usually not how it plays out. So let's get into what's really happening in that courtroom. Dennis, good to see you.
Hey, good morning, man. It's great to see you again as well.
First court appearance, obviously, most people probably don't go to court more than once in their life, or, unless they're, repeat offenders, so to speak. But, when someone does walk into court for the first time, what do they usually think is going to happen? And where have you found they've been completely off base?
So, a lot of times in criminal cases, right, somebody gets arrested and then they wait for the court date and they think, okay, this court date, this is when I'm going to be able to explain everything and I'm going to show them that I didn't do this. We're going to get it all resolved. And so a lot of times their expectation is because it's the first court date that we're going to decide everything. And it's just not that way. Right. So the first court date in a criminal process is called an arraignment. And at the arraignment, the judge is required to read out what you're accused of. So basically, it's just an opportunity for you to know, if you don't already know, A, what the charges are, and then B, for the court to know how are you going to respond. Right. So in an arraignment, there's only two options. You either say guilty or not guilty. Okay, so I'll explain what guilty means. Guilty means I accept whatever you said I did. I accept full responsibility. I admit to it. And then the judge is in charge of doing sentencing. So we never say guilty at arraignment. The option that we always use is not guilty. Not guilty says, I'm going to defend myself, right? I understand that you've charged me with whatever you've charged me, but I'm not admitting to anything and I'm going to defend myself. And so the most likely scenario is that for my clients, they don't go to arraignment at all. I waive their appearance at arraignment. So I file a document in advance that says, whatever the charges are, we're not admitting anything. We're entering a plea of not guilty. I waive their appearance at arraignment. So they don't, A, have to be there, B, have to be humiliated, because you never know who's going to be in a courthouse. Your employee, your neighbor, your boss. But C, because there isn't anything meaningful for you to say other than, I have a lawyer, my lawyer's going to defend me. And so the other thing that I do at arraignment is I demand the prosecutor give us all the evidence they have. So as soon as we say not guilty, at that point, I say, okay, give us all the discovery. And from that moment on, the prosecutor has an obligation to not only recognize me as the lawyer, but to give me whatever they have in the case. So arraignment is something that it's a first court date. It's not going to resolve anything other than to signal to the judge you're going to defend yourself. And I would waive the appearance of my client at 99.9% of the arraignments.
Got it. Okay. Now, for someone who's maybe never been there before, right? Can you describe, what's the courtroom actually look like and feel like on arraignment day for someone walking in there? Paint that picture.
Usually what happens on arraignment day is it's a people who don't have a lawyer, right? They're there. And so the judge may have 20 or 30 cases on any given day. So the judge is going to be on the bench. There'll be a prosecutor in the courtroom. There'll also be a public defender in the courtroom. There's generally going to be a court clerk. They're the assistant to the judge that's recording everything. There may be other people there because there may be some family members, witnesses. There's always going to be a court deputy, right? Somebody there for security. And sometimes there are other lawyers there. So mostly it's going to be people who are unrepresented, who are showing up for the first time, and they're telling the judge, hey, I don't have a lawyer. Can I apply for a public defender? Or can I get time to hire a lawyer? Again, for my clients, I usually waive their appearance so they don't have to be there. And it's, it's a perfunctory thing. The judge can't spend
Gotcha.
more than
Yeah.
2 or 3 minutes on every case. Imagine you got 30 cases on the docket. You just want to hear
Right.
guilty or not
Yeah.
guilty.
Yeah. People are lined up. So the judge calls a case. What's the judge focused on in that moment?
Whether or not you have a lawyer, whether or not you qualify for the appointment of a public defender, and whether or not you understand. Because some people go to arraignment, they don't speak English. And so if you don't speak English, the court will have interpreters available. In Florida, we have, a lot of Spanish speaking people. So
Sure.
Spanish speaking interpreters are pretty routine, but they also have the ability to translate into Portuguese or Creole or other languages. If you have, let's say you're Russian, they have a thing called it's a phone service, but they call somebody on the phone that speaks Russian and they swear them in
Oh,
and
yeah.
they translate. So the process of arraignment is a procedural process. It's designed to inform you of the charges and for the court to be informed. Here's what it's not. It's not an opportunity for the hearing of evidence, the
Mhm.
taking of testimony. So there won't be witnesses there. The cops aren't there. Victims
Right.
usually
Right.
aren't there. So it's not traditional court where you're going to contest something. It's administrative to the extent that you're just saying, hey, man, are you going to defend yourself or are you going to admit the
Yeah.
charges?
Yeah. So are there any decisions that actually get made at that first appearance that people don't realize?
There's not any decisions that the client has to make, right? Once you've decided to hire a lawyer, you're going to defend yourself. You're going to be tendering a plea of not guilty. The judge isn't making a decision on a case by case basis, but the judge is calendaring cases because for everybody who says not guilty, right, that's not the end. That's the beginning.
Right.
So the judge
Right.
says, okay, you've entered a plea of not guilty. You've hired Mr. Quintana as your attorney. We're going to set this case for the next court date, right? And the
Got
next
it.
court date is usually called a pretrial conference. In some jurisdictions, it's called a docket sounding. But the idea is, okay, you're going to defend yourself. We're not just going to go straight to trial, right? So prior to the trial, let's have a meeting. Let's have like a status, right? And at the pre-trial conference, you guys come back, client comes back, attorney comes back, prosecutor comes back, and you let me know, let the judge know what's going on. So the decision that's made at arraignment is when is the next court date, and
Okay.
so they'll notify you, right? If the client doesn't go to the arraignment, they'll tell me. They'll also the clerk, the assistant to the judge, clerk of the court, they'll send out a notice, and they notify not only the client, but they also notify the bonding company, the bondsman. If most people are out on pretrial release on bond, they'll notify the bondsman so the bondsman knows to make sure that you're there for the court date. So in terms of decisions, that really is the extent of it. There are
Got it.
exceptional cases. So let's say I have a case that is a racketeering case, and there's 18 co-defendants.
Ah,
A judge might say at an arraignment like that, right? Because are all 18 people going to say not guilty? Is any one of them going to admit to anything? But once we do all of that, we figure out. Let's just assume everybody, all 18, say not guilty. Then the judge is going to say, well, this is going to be a complicated case, and so instead of setting it for the normal pretrial, which might be 6 to 8 weeks away, they might say, we're going to set a pretrial for this 3 or 4 months down the road, right, to
oh,
give
okay.
you the opportunity to get all
Prep
the
time.
information. Yeah, but that's exceptional. That's not normal.
Right. How much does that first court date impact the overall direction of the case?
Well, if you're going to defend yourself, you're generally just saying not guilty. And so, the first impact is, hey, you're not going to admit to anything. And now it shifts the burden, directly to the prosecutor. It doesn't shift, but it puts the onus on the prosecutor to man up, right? Okay, you guys said he did something or she did something. Where's the
Prove it.
proof? Get
Yeah.
it to them. And then, in criminal, we don't say or do anything until we have the evidence, right? So imagine you go to the doctor and you say, hey, doc, I don't feel well. The doctor doesn't say, I'm gonna schedule you for an operation on Tuesday,
Right.
right? The
Right.
doctor is usually going to say, well, tell me what 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 are the
What'd you
symptoms you
eat?
have. Yeah, and let me do some diagnostics, right? Let's do some x-rays or some blood work. Let's try to narrow down what it is you really got, right?
Yeah. Yeah.
And then we'll figure out how we're going to treat it. Well, that's what we do at arraignment. By saying not guilty, we don't walk in there and go, not guilty, it wasn't me, I was somewhere else, you know. No, you just say, hey, not guilty, give me what you got. and
Yeah.
and then we look, we review, and we explore where are the defects. So based on what they have, that's how we start figuring out how we're going to respond and start crafting a
Right.
theory of defense.
Yeah, that makes sense. That makes sense. So let me ask you this: given your experience, Dennis, and the years that you've been doing this, what are ways in which maybe you've seen people hurt themselves at the early stage without even realizing it? Are there like foot and mouth situations?
Absolutely. No, no, no. Listen, that's a very good question because let's just say, hey, you've never been to court, you didn't get a lawyer before you went to court, and you're not really sure what to expect. So when you get up, they say, okay, you've been accused of this. How do you respond? Right? If you start with something other than not guilty, whatever you say can and will be used against you, right? So if you start saying, hey, I wasn't there, hey, it wasn't me, hey, that cop was a jerk, whatever it is, the judge should immediately caution you, hey, I don't want to hear any of that. This is not the time and place for that. You shouldn't be saying anything. I just want to know, are you going to defend yourself or not, right? But sometimes they don't get a chance. And people have, like you said, foot and mouth. I say diarrhea of the mouth. They just start,
Yeah.
they've got a speech that they want to get out. Okay.
Yeah.
That's
Yeah.
not the time, man. That's not the time. And so that's where you can start messing up because even something simple like, look, I didn't mean to do it, right? Or look, I just want to apologize, right? Well, what you're saying is that I'm implicitly confessing to something. I didn't
I
mean to
did
do
something.
something means I admit something, right? I'm accepting
Yeah.
responsibility for something, and you should never do that, right? You
Right.
should never,
Yeah.
because
Yeah.
if the cops and the prosecutor don't have the sufficient evidence to prove it, then it doesn't matter what actually happened, right? It's only a
Yeah. You
question
don't
of
want to
what
give them
they could
more
prove.
evidence.
You don't
Yeah.
want to give them any evidence. That's exactly right.
Right. What's the scenario now? Okay, that's the, guy with no lawyer making those mistakes. How does that play out differently when, someone shows up with a lawyer, right? Versus trying to do it on their own.
So usually when somebody shows up with a lawyer, then the judge will address the lawyer. So the judge recognizes that the lawyer is there as your agent, as your attorney. And so not only do they have your consent, but they're there to protect you. So the judge will address the lawyer and not the client. And so it's usually best for the client not to say or do anything. What I
Yeah.
say is an evidence. I can argue, I can make all sorts of stuff, right? But what an accused person says is called an admission, right? It's an admission against interest. It's something that can be used by the prosecutor. Prosecutor's there, right? And not only is prosecutor
Yeah.
there, but the court is being recorded.
Yeah,
So
they're taking notes. Yeah.
they're taking notes of whatever it is you said, right? The other thing that happens at arraignment is if you go, you want to make a good impression, right? You shouldn't
Oh.
go. You should have a lawyer. You shouldn't go. But if you go, right, don't show up with, a T-shirt that says something
Yeah.
vulgar about the court, or I
Yeah.
hate all
Screw the
cops,
police
or
or what. Yeah. Yeah. Right.
exactly, and
Yeah.
don't make any enemies.
Yeah.
Don't start looking at other people. At the prosecutor. You're on, right. It's like a play,
Yeah.
and
Yeah.
so they're observing you, and so they're drawing nonverbal cues about you, and that may
Hmm.
be something um, that can hurt you in the future, right? So
Yeah.
when you go to court, you want to go to court like you're going to church, right? Like you're going to work, like you're going to
Yeah.
somewhere that matters.
Yeah.
You want to look presentable, and you don't want to make a bad impression, right?
Sure. Yeah. Yeah.
So that's why I try to keep
It's
clients
interesting.
out of court as much as possible.
I had a conversation with an attorney, and we forget exactly what our specific topic was, but we got to this place where it's like, you're playing a game. There's a game, and there's just rules of the game, and you just follow those rules. It's almost like forget about what you might do in real life or, whatever it is. It's like this parallel universe called court or the justice system. And you kind of there's certain rules of the game that, like any game, you don't know it until the rules are read to you, you know? So
Listen,
it's,
you nailed it. You're exactly right. So so let's talk about chess. Okay, chess is a
oh,
game. Chess has rules, and those rules are specific, right? You have to take turns. B, the
yep.
different pieces can only
Yeah, they
move in a
move
certain
different
manner,
ways. Yeah.
right?
Hmm.
Sometimes there's time restrictions on when you can do it.
Yeah.
And so court is like that. Court has rules, and those rules, number one, are there to protect the accused. Number
Yeah.
two, they're also there to make sure that the process is fair, right? So there are rules about what kind of evidence is acceptable and how that evidence needs to be introduced. And so, for example, if I go to court, I can't go to court and call a witness that says, "Hey man, I heard that the cop is really a bad dude," right? Right.
Yeah.
When a witness is testifying about something that they heard or something that was said that was not in their presence, that's called hearsay, right? I didn't see it, I didn't experience it, but I'm here testifying under oath about something that I think I heard or I was told.
Yeah.
That's
Someone
inadmissible
told you.
because second party evidence, is generally not as reliable as first party evidence. And so
Right.
the process needs to be insulated from much of hearsay, right? And it's not
Hmm.
just hearsay, it's also character evidence. Hey, listen, that guy's a real dirtbag. I don't, you think he's a victim, but I know that he's a whatever, 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 right?
Hmm.
Again, character evidence is not admissible. So how does that
Got it.
translate? Well, in chess, right, you can't take two turns. You can't move a piece in a manner that it's not allowed. So when you break the rules, then there's a consequence. And so the judge is the referee. The judge is the rule. This they decide
Yep.
what's allowed, what's not allowed. Right. The players are presumed to know the rules. The issue is, have you ever heard about like taking a test that you study for the test as opposed to studying the knowledge? Right. There are test
Oh yeah,
taking
yeah.
techniques.
Like it's like to you learn how to take a test,
Exactly,
so to
exactly.
speak.
Or think of it in sports, right? You may have an obstacle course, right, to qualify. So let's say I want to make a team, but in order to make a team, I have to run 100 yards and see how fast I do that. I have to jump a certain height, right? So
Yeah.
you don't test for playing football. You test for how fast can you run, how fast can you jump, or how high can you jump, whatever the
Yeah. Yeah.
metrics are, right? Well, that's what court is. Court is a test, and the issue is not what you think, but what the rules are and what the evidence shows. Okay, so let me try to give you an example. Let's talk about boxing. All right, you got two boxers in a ring, you have a referee. Okay, boxers are allowed to hit in a certain manner. They're not allowed to hit below the waist, for example, or in the
Right.
back, for example. If they do, that's a foul. Um, at the same time, a boxer is not allowed to have his buddy come and jump over the ropes and come in the ring, and now it's two against one, right? That's a
Right.
foul. Well, the rules of evidence are the same way, right? I'm not allowed to bring hearsay evidence in. I'm not allowed to speculate. I'm not allowed to just introduce evidence that isn't properly authenticated. And when I say I'm allowed, right, the rules apply to everybody. That means the government
Yeah.
isn't allowed either. And so that's what I do, right? What I do is I know the rules. B, I make sure that the prosecutor abides by the rules, and those rules apply to the conduct of the police. So
Yeah.
the police have
Right.
rules. So and that's what we
Well.
do. So so I know I'm talking a lot, but I mean what I'm trying to do is get at why you're asking this. And why you're asking this is a very valid point. The point is it's not really about what you think happened. It's only about what they can prove or what they can't
Yeah.
prove.
Yeah. No,
So
it's a
my job is to keep them from
point.
proving stuff.
Yeah. Well, no, and to continue the boxing analogy, and we've got to wrap up for time here, but that like the boxing in the ring, you need a corner man, right? And
Yeah.
in this context, you're the corner man, and you know the rules. This is what we're going to do, and you're going to tell me what to do out there and what not to do. And so, super great, Dennis. Really informative. Great talking to you, and I look forward to a future conversation for sure.
Awesome. Thanks, man. I look forward to chatting as well.
That's it for today's episode of Lessons from the Sensei, Law, Business, and Life. If you'd like to learn more or speak with Denis Quintana, contact Sensei Legal at 407-694-5403. As always, thanks for listening. Don't forget to subscribe, share a link, leave a review. It all helps others find us, and we really appreciate it. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.